All right, do we have anyone that's agreed? Shoes, are you ready? You may. CR 22-6, Robert Paul Kane. Mr. Kane, if you'll make your way to the podium, sir. All right, Mr. Kane is set for pre-trial today. Have you received all of the discovery from the state?
Yes, you're right. You received it all from them.
Okay, and did you receive it in sufficient time to be able to determine whether or not there are any contested pretrial motions for today?
Yes, right.
Okay, no contested pretrial motion requests? Okay, all right, then the court will set this for docket call. And we'll set this on October 13th. You have any scheduling issues that day? Okay, we'll set that for docket call on October 13th. And Mr. Hughes, on that day, I will expect to hear from you and the state whether or not there's going to be a plea agreement or there's going to be a request for a jury trial or a bench trial.
Yes, right.
Okay. Yeah, you could go ahead. I don't need to sign that.
Oh, okay.
Yeah, if you'll just get the dates on there and have Mr. Kane sign it. And then once everything's executed, leave the white copy for me and the yellow copy goes to Mr. Kane. And white copy will stay here, yellow copy goes to the defendant. Yes, you may.
You wanted us to sign a jury waiver?
CR 19-258, Jake Burton. Mr. Burton, if you'll make your way to the podium, sir. All right, Mr. Burton, if you will raise your right hand, I'm going to place you under oath. Mr. Burton, do you swear that the testimony you give to the court today, that it'll be the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. All right, you are Jake Taylor Burton, is that correct? And in this case, you're represented by your attorney, Miss Deborah Beasley, is that right? And it appears to me that you have executed a waiver of jury trial document in which you are telling this court that you understand that you have the right to have your case heard by a jury of your peers. You have the right during that jury trial to confront and cross-examine the state's witnesses. And you understand that that jury trial right cannot be taken away from you. However, you also understand that you may intentionally, knowingly, and voluntarily waive that right of your own free will and accord. Are you telling me that you have considered your right and you are asking the court to allow you to waive that right? And you understand that once you waive it, there's very limited circumstances in which that can be restored to you. And you've taken the time to consider this with your counsel, and this is what you're asking the court to approve. And Ms. Beasley, you're also joining your client, and you believe that he is doing so voluntarily. And the court will also note that this is also approved by the attorney for the state, Ms. Heisel. The court then hereby approves the waiver of jury trial in open court.
Your Honor, he actually has 2 cases on the approval of the court. He does have another county I'm dealing with. We've asked for this case to be set on October the 20th for a plea.
Okay.
We'll do a plea at that time for both of these cases.
Does he have 2 cases in this court?
Yes, Your Honor.
Okay, and so the other case is,
It's a newer case.
okay, so has it not hit the,
It has, but I signed a reset sheet, Ms. Patty has it, it has both file numbers on it, setting for a plea day with approval of the state as well.
okay. All right, then in CR 19-258, then the court will set this for plea, and you said on October 20th?
Yes, Your Honor.
And you've already had that notice sheet given to Mr. Burton? Okay, all right, free to go. We'll see you back on October 20th.
Thank you.
Thanks, Mr. Burton. Counsel, anyone else ready at this time? Mr. Stevens? Are you ready on Mr. Ekrit? You ready on Mr. Ekrit?
Yes, sir.
And are you standing in for Brad this morning?
He showed up and brought his up.
Oh, there he is.
He got some free papers.
Okay, good. All right, CR 27-7, State versus Blake. Ekrit, Mr. Ekrit, if you'll make your way to the podium, please, sir. All right, and Mr. Stevens, Mr. Egret set for pretrial today,
Yes, sir, no formal pre-trial.
and you've received all of your discovery?
Yes,
And have you received an offer in the case?
yes.
Okay, good. All right, there being no contested pretrial motions, the court will set this for docket call. Are you available on October 13th, Mr. Stevens?
Judge, I'm in the 175 at 9 o'clock. If you could do it in the afternoon or later in the morning, I heard you staggering things out.
Afternoon is going to be reserved for jail.
Okay.
I could do on the hour, 9, 10, or 11,
Can
or
we do
what,
11?
what about October 15th? Is that a better day? No, sir, same. You have a pretty,
CPS that day.
oh, that's even worse. You have a pretty heavy docket on the 13th and the
No, sir,
173rd.
I've just got one case. It'll be by Zoom, so.
Your case in Henderson will be by Zoom.
Yes, it's not a plea, they just a snap.
What if we set it for 11? Do you think you'll be out of there by
Oh,
11?
absolutely. That'd be
Okay.
great.
Well, let's set it for 11 then. All right, Mr. Egret, I'm going to set you for docket call on Tuesday, October 13th at 11 a.m. Mr. Stevens got a notice of setting here. We'll have you sign that and then we'll give you a copy and you'll be free to go. The white copy will stay with the court, yellow copy goes to the defendant. You can just lay it on that table right there. Thank you, sir. Anyone else that's ready, counsel? Mr. Head?
All right, we're ready on this.
CR 23-7, State versus Joe Tubbs. Mr. Tubbs, if you make your way to the docket or to the podium. We are set for docket call today, Mr. Head.
Yes, sir, Your Honor. We've provided some additional information to the district attorney's office this morning. We hope we'll have a resolution of this fairly soon. I think they needed some additional time to look over that. But if we could get another court date as soon as practical.
State, any objection?
No, Your Honor, that's correct.
Do you know about how long you may need, Ms. Heisel?
Judge, I think 2 weeks should be sufficient for me to consider producing evidence.
The next available would be less than 2 weeks. It would be 2 days shy of 2 weeks. It'd be September 29th. Is that too early? Okay. All right, then Mr. Tubbs is set for an additional docket call on Tuesday, September 29th. Do you have any other scheduling issues on that day, Mr. Head?
Not that I'm aware of.
So 9 a.m. is okay?
Yes, sir, Your Honor.
That's all right.
Always good.
Do you like Mr. Files, Mr. Harrison, bring your staff with you and they can knock that out for you?
Yes, sir. Your Honor, we did have one other issue we just wanted to ask the court about. Mr. Tubbs is currently under bond conditions. We think this is going to be resolved quickly, but one of those conditions is that he not even have any alcohol at all to drink. We'd ask that the court maybe consider amending that to not consume alcohol in excess, that if he wants to have a beer or a glass of wine, he not be prohibited from doing that. And there's no allegation that alcohol or drugs or anything was involved in this offense, Your Honor. And no prior criminal history that I'm aware of.
Okay. So discovery, you got everything in discovery.
Yes, sir.
All right, if you'll sign right there, have Mr. Cox or Ms. Heisel sign right there, have Mr. Tubbs sign. We'll do that and then we'll take up the. That'll be his copy. All right, so we're set on the 29th. Do we anticipate that it may result in a plea agreement to probation or a dismissal?
Your Honor, there's a misdemeanor probation offer. We are providing additional information in the hopes that we can have it dismissed, but that's obviously not an offer at this time, but there is a misdemeanor probation deferred offer.
So what I'm considering is we're in less than 2 weeks, we'll have a decision. If it's dismissed, then I guess he can drink in accordance with the law. And if it's not dismissed and he's placed on probation, then he's not gonna be allowed to drink on probation either. So I'm not going to amend his conditions of pretrial release at this time, but if we were set out further, I may take that under advisement, but
Yes, sir.
less than 2 weeks, we'll know
Yes, sir.
whether he can or whether he can't.
Yes, sir.
So
Thank you.
not long to hold off.
Okay. Thank you, Your Honor. May he be excused.
Yes, we'll see you back on the 29th. Mr. White, are you ready on any of your clients?
Your Honor, I have 2 cases where I filed the pre-trial motion times that the state had any opposition. That person, I would make
CR 20-103, Scott Allen Bowden. Mr. Bowden, I'm sorry, sir. If you'll just come up to the podium there.
as I said, Your Honor, I filed the 3 discovery motions that I typically file in the state had no opposition.
No
The only situation, as far as this vote is concerned, I just now got the discovery today.
Okay. So you're going to need additional time on pretrial.
I believe so.
All right, court's going to reset pretrial to October 13th. No objection by the state?
No, Your Honor.
Okay. That'd be at 9 a.m. And Mr. Bowden, you have signed your conditions of pretrial release? Is that correct, Mr. Bowden? When you went back here and you met with the pretrial release department, you signed some paperwork? Oh, you have not? Okay, then I need you to have a seat over here until the pretrial release department calls you in. And once you sign your paperwork, you'll be free to go.
Your Honor, the next case that I am with, Your Honor, the item of the receipt. Your Honor, who gets what? I guess
White state, yeah, white copy stays here. Yellow copy goes with the defendant. And Mr. Bowden, I'm going to have you come up here and have a seat so the pretrial release knows to call you. Otherwise, they may leave you sitting out there for the rest of the morning. CR 20-141, Ivan Rostro Garcia.
Your Honor, pretty much the same amount, 3 motions that I originally filed. No opposition to the second. I wound up getting this discovery yesterday.
Okay. And is the receipt of discovery, is it being made available through the online discovery or are we picking it up?
I still have a DVD.
Any objection from the state? All right, court's going to reset this for an additional pretrial on October 13th at 9 a.m. And has Mr. Garcia signed his pretrial release papers? Okay, go ahead and have a seat over here and they'll call you back, sign some paperwork with you. And then after that, you'll be free to go. Mr. White, any update on your other two clients, Mr. Fincher or Mr. Mackey? Is Nicholas Fincher here? Or Montreal Mackey? Are you just gonna wait, Mr. White, and see if they show? Mr. Springer, are you ready? This is CR 18-340, State versus Richard Randall Springer. The court will note again for the record that Mr. Springer has been granted authorization to represent himself in this matter. And I believe at the last hearing, there was an issue regarding your request to retest substance. And I think at that time I asked you to visit with the state. We all to share, discuss discovery, and it appears that maybe y'all reached a plea agreement.
Yes,
All right, good. That's a long way about going this case. All right, Mr. Springer, if you will, raise your right hand. Mr. Springer, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, let me put your hand down. Give me just one moment. I'm gonna look over your paperwork. Ms. Heisel, help me with this fine again. I know the fine amounts have kind of gotten a little different. The judgment says a $3,495 fine. And then the written plea admonishment say a $4,000 fine. Is that a difference in additional?
It's a miscommunication
Oh.
between myself and Ms. Abby.
Okay.
Mr. Springer and I had an agreement that his grand total with all the reimbursements, everything would be 4,000. So I had Ms. Abby adjust the judgment after the payroll.
Okay, so let's do this. I'm gonna send back the written plea admonishments and just have that fine change there. And if you and Mr. Springer will initial that for me. Stevens, how are you, sir? Been good. So far, I guess. So far, so good. All right, and I also noticed that the state certificate of discovery was dated in 2018. Has anything changed since that date?
No, you're wrong.
right, Mr. Springer, I've got a few questions for you. Are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? In this case, you have requested to represent yourself, and you went through a previous hearing with the previous judge of the 294th District Court, the Honorable Teresa Drum, and Judge Drum at that time granted your request to allow you to represent yourself. And you are still desiring to represent yourself today, is that correct? And you still understand that you can assert that right, and the court could allow you to retain an attorney. And if you cannot afford one, one could be appointed to represent you in this. You understand that? Yet, having understood that, you still wish to proceed and represent yourself. And have you taken ample time to go through this plea agreement paperwork, your judgment, and thoroughly review this documentation? And do you feel like you have understood everything that you have read and signed? Is there anything in this paperwork that you believe that you do not understand or need clarification on? And it's my understanding here, by looking at the paperwork, that you have a plea agreement in which you would be pleading guilty to a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. And in exchange for that plea of guilt, the state's going to recommend that you be prosecuted under section 1244A of the Texas Penal Code, which would result in you being a convicted felon for that offense. But the prosecution would proceed under the terms of a misdemeanor punishment, in which their recommendation is for the court to assess your punishment at 43 days confinement in the Van Zandt County Jail, with the court giving you credit for 43 days of time served, a fine of $3,495, restitution of $180, and court costs of $290. Is that the plea agreement that you want the court to approve? And Mr. Springer, you understand, or you need to understand, that having been indicted with a state jail felony offense, the range of punishment for that offense is confinement in the Texas Department of Criminal Justice for not less than 6 months, nor more than 2 years, or a $10,000 fine. And if prosecuted under section 1244A, confinement in the Van Zandt County Jail for a period not to exceed 1 year, or a fine not to exceed $4,000. You understand that those ranges of punishment?
Yes, sir.
So, Mr. Springer, at this time, I'm going to ask you, how do you plead to the state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
And Mr. Springer, are you pleading guilty because, in fact, you are guilty of committing that offense?
Yes, sir.
And Mr. Springer, has anyone threatened you, forced you, or pressured you to plead guilty to something that you're not guilty of?
Yes, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Springer, also, is there any objection to the court admitting into evidence the stipulation of evidence in this case, which contains your indictment and the offense report and lab reports? Any objection to that?
No objection.
All right, the court hereby admits State's Exhibit 1, the stipulation of evidence, and takes judicial notice of Mr. Springer's judicial confession. Is there anything further from the state? Anything further from the defense? All right, Mr. Springer, based on the evidence before the court will follow the plea agreement in this case. The court hereby convicts you of the state jail felony offense of possession of controlled substance, penalty group 1, less than 1 gram. The court assesses your punishment in accordance with the plea agreement under section 1244A as 43 days confinement in the Van Zandt County Jail. The court gives you credit for 43 days of time served on that sentence. Court assesses a fine of $3,495, orders you to pay restitution in the amount of $180, and assesses court costs in the amount of $290, and a reimbursement fee of $35. Mr. Springer, how are you going to discharge your fines and court costs and fees? Are you paying all that today, or are you going to need to be on a payment plan? Payment plan? All right, so when you're done here, I'm going to have you report to the end of the hallway to meet with the court collections officer, Ms. Bonnie LaPrade, and she'll set you up on a payment plan and tell you how to discharge that. Your failure to hold up to your terms of this agreement would result in the court issuing a warrant for your arrest. All right, Mr. Springer, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of your sentence. And just to stay where you're at in just a moment, I'm going to have you step up to be fingerprinted with the bailiff, after which time you're to go down to the end of the hall, going to the west there, and last office on your left. All right, Mr. Springer, I'll have you step up here with my bailiff. Be fingerprinted, and I'll have a copy brought to you, okay? Ms. Beasley, are you ready on Ms. Borchardt? I noticed that she's on Zoom.
Your Honor, if we could, have a little bit more time on that.
That's fine. That's fine. Okay, ready. Is this on Mr. Broderick?
Yes, sir.
Brandon Broderick?
Oh, Your Honor. Court here, the approach.
Yes.
I do have a big impact statement.
You stay right there at that podium. There you go. All right, if we can, just take a break in this real quick. I need the written plea admonishments filled out as the charge, level, defendant, all this. It's either signed, but there's nothing in there about what the plea agreement is. So just have y'all fill that out real quick. You ready? I saw Miss Beasley jump up, but he gave me the eyebrows. He gave me the, Mr. Stevens.
I hear you.
Hmm.
It was at the very top of this document.
Yeah. Austin Banks. Yeah, mine's a little different. CR 19-298, Austin William Banks. Mr. Banks, make your way to the podium, please, sir. Mr. Banks, if you will, raise your right hand. I'm going to place you under oath. Mr. Banks, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down.
There's also a misdemeanor companion case that we're also going to do.
Okay. Okay, good. All right, this is in cause number CR 19-298 and also 2019-358. Mr. Banks, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Mr. Brad Stevens. Are you pleased with his representation of you? Feel like you've had sufficient time to discuss both of these cases with him and have all of your legal questions answered? Anything that you don't understand about the paperwork that you have read and signed? And Mr. Stevens, do you believe Mr. Banks to be competent today?
I do, Your Honor.
And do you believe he understands and appreciates the nature and consequences of his plea agreement?
I do.
Mr. Banks, in cause number CR 19-298, you were charged by indictment with the third-degree felony offense of injury to an elderly or disabled individual. However, it appears that in this plea agreement, the recommendation is for the reduction of the charge to assault against an elderly or disabled individual a Class A misdemeanor. Do you understand the range of punishment for a Class A misdemeanor is confinement in the county jail for a period not to exceed 365 days and a fine not to exceed $4,000? Do you understand that? And then cause number 2019-358, you were charged by complaint and information with a Class A misdemeanor offense of driving while intoxicated with a BAC greater than or equal to 0.15. And the range of punishment is for that offense is the same as the other one, for a period not to exceed 365 days and a fine not to exceed $4,000. Do you understand that? That means any plea agreement you reach or any sentence that's ultimately handed down by the court must be within that range of punishment. I'm going to ask you then, as to the Class A misdemeanor offense of assault against an elderly or disabled individual, how do you plead? And in the 2019-358, on the charge of driving while intoxicated with a BAC greater than or equal to 0.15, Class A misdemeanor, how do you plead to that charge? And Mr. Banks, are you pleading guilty to each one of these charges because in fact you are guilty of each one of these charges? Has anyone threatened you, forced you, or otherwise pressured you to plead guilty to either of these when in fact you're not guilty? All right, the court will accept the defendant's plea of guilt in each cause. Mr. Stevens, any objection to the admission of states one?
No, thank you.
All right, court admits states one in each case respectively and takes judicial notice of Mr. Banks' judicial confession. Is there anything further from the state? Anything further from the defense?
No, Your Honor.
Does this have both of your cases on it?
It honestly doesn't have the misdemeanor on there, but I'm not worried about it.
Why don't you put it on there?
I'm gonna match the judgment. I gotta get happy.
Oh, it's not?
No, sir. I think it's fine, Your Honor.
Okay.
Okay, not a problem.
All right. All right, Mr. Banks, based on the evidence before the court will follow the plea agreement in each one of your cases. CR 19-298, court hereby convicts you of the Class A misdemeanor offense of assault against an elderly or disabled individual, assesses your punishment at 1 year confinement in the Van Zandt County Jail. Court will suspend that sentence and place you on community supervision or probation for a period of 18 months. Court will assess a fine in the amount of $2,500, and the court will order the sentence in this case to run concurrent with 2019-358. In addition, you are ordered to pay court costs of $270 and reimbursement fees of $860 in that cause. In the DWI charge 2019-358, court follows the plea agreement, convicts you of that offense, assesses your punishment at 1 year confinement in the Van Zandt County Jail. Court will suspend that sentence, place you on community supervision for a period of 18 months. Court assesses a $100 fine, $270 court costs, and a $15 reimbursement fee. Mr. Banks, have you ever been on probation before? And did you successfully complete it or unsuccessfully complete it? So you know how probation works, you know what's required of you, you know what's expected of you, but more importantly, you also know what is the consequences for your failure to comply, correct? No, I don't have the conditions of community supervision on either one of these. Mr. Banks, Austin Banks, has he seen those?
I do not.
All right, just ask that you stay and go over those conditions with him. I'm gonna have you step up here to be fingerprinted with the bailiff.
Maybe I see that right.
Yes, yes, thank you, Mr. Beasley. Ms. Beasley, you ready?
Huggins?
Mr. Huggins. CR 2124, if you'll make your way to the podium. All right, this one hasn't been sworn by the clerk yet. So. There's no legal prohibition for me placing someone for aggravated robbery on deferred. Is that right? That's not a. Okay. Yes, we ready, Mr. Broderick?
Got those completed.
All right.
Correct.
All right. All right, Mr. Broderick. All right, one more question. So on the judgment, it says third degree felony, but it's enhanced, so it should say second degree. Otherwise, that's going to cause a problem. 12 and 10
I think that's true, Your Honor. It should.
say, that should say second degree felony.
Yes.
Is Mr. Cox the one handling? Ms. Heisel, is Mr. Cox handling Broderick?
We have no objection to just the front page of the judgment being rerun, Your Honor. Or the examination.
Is there a Brooks notice?
Your Honor, it was actually alleged in the indictment.
But it says third degree and there's an enhancement, but there's going to have to be a plea of true to these enhancement paragraphs here in order to get that. Otherwise, TDCJ is going to look at that,
Kick it back.
kick it back, I think.
I'm getting this,
Yeah, so we'll need to have the degree change and then enhancement paragraph 1 and then finding on enhancement paragraph 1. Here you go, Mr. Head. I'll give these back to you one more time. All right, Mr. Broderick. Sorry, sir. Just you have a seat. You can sit up here closer. You don't have to go to the back. Just stay spaced out. Mr. Schmidt, are you ready? On Lowry. CR 19-237, Rebecca Elizabeth Lowry. Hey, let's go and move the podium back a little bit, if you don't mind. There we go. I like it better. All right, Ms. Lowry, if you will you raise your right hand? Ms. Lowry, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Mr. Schmidt, will you help her there with that microphone? There we go. All right, thank you, Ms. Lowry. Give me one moment. I'm gonna look over your paperwork and then we'll proceed. All right, you are Rebecca Elizabeth Lowry, is that correct? Ms. Lowry, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? What have you been diagnosed with? And are you currently on medication for bipolar? And when's the last time you were on medication for that disorder? 2011. And do you feel like not being on medication today anyway inhibits your ability to understand and appreciate the proceedings against you? No? You feel like you have a rational thought today? Okay, and Mr. Schmidt asked counsel for Ms. Lowry. Do you believe she's competent today? And have you seen any evidence of her mental diagnosis having any effect on her competency?
No, guys.
All right. Let's see, Ms. Lowry, you have been charged by indictment with the state jail felony offense of driving while intoxicated with a child under 15 years of age. The range of punishment for a state jail felony is confinement in the Texas Department of Criminal Justice State Jail Division for a period not to exceed 2 years or to be less than 6 months. However, there's a plea agreement in this case that if in exchange for you pleading guilty, the state is recommending that your punishment proceed under section 1244A of the Texas Penal Code, which would be a class A misdemeanor range of punishment, which would mean that the range of punishment in this case now becomes confinement in the county jail not to exceed 365 days and a fine not to exceed $4,000. Do you understand that range of punishment? That means that any plea agreement you reach with the state or any sentence that is handed down by the court must fall within that range of punishment, okay? So Ms. Lowry, to the charge of driving while intoxicated with a child under 15 years of age, a state jail felony, how do you plead? Guilty or not guilty? And Ms. Lowry, are you pleading guilty because in fact you are guilty? Has anyone threatened you, forced you, or made you plead guilty to something you're not guilty of? All right, court will accept Ms. Lowry's plea of guilt. Mr. Schmidt, any objection to states 1? Court admits State's Exhibit 1, stipulation of evidence. It takes judicial notice of Ms. Lowry's judicial confession. Anything further from the state, from the defense? All right, based on the evidence before the court will follow the plea agreement and the recommendation from the state in this case. The court hereby convicts Rebecca Elizabeth Lowry of driving while intoxicated with a child under 15 years of age. Court assesses her punishment in accordance with the plea agreement under section 1244A of the Texas Penal Code. Assesses her punishment at 31 days confinement in the county jail. Court awards credit for 1 day of time served towards that sentence. Court assesses a fine of $1,500. Court orders Ms. Lowry to serve out the remaining 30 days in the Van Zandt County Jail in accordance with Exhibit A, special order for committing to jail. Court also assesses a fine in the amount of $1,600, $290 court costs, and assesses a reimbursement fee of $35. Ms. Lowry, do you understand that after you serve your sentence in jail, you're still going to be obligated to Van Zandt County to pay your fines, court costs, and reimbursement fees? Do you understand that? If you cannot pay all of those at one time and request a payment plan, one can be provided to you. However, your failure to comply with that compliance plan, with that collection plan, would result in the court issuing a warrant for your arrest. Do you understand that as well? All right, Ms. Lowry, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm gonna have you step up here to be fingerprinted with my bailiff. When you do report to the Van Zandt County Jail to serve your time beginning on September 25th, you need to bring an ID with you along with a copy of your judgment and a copy of this Exhibit A that tells the jail when you're supposed to be there. If you show up without either your ID or these, they're not gonna let you in. Okay, and that's not good for you because I'm telling you, you're ordered to take those. And if you don't, that's going to be bad news for you. Okay? Not today, no. You ready, Mr. Lane? Tristan Lane, CR 2014, CR 18-435, CR 18-436, CR 18-368. All right, I believe we were set for status of attorney today, and it appears that Mr. Schmidt, you have been retained or appointed?
I was retained, Judge, retained at the last meeting. We will go in the next one for one attorney prior to that, which is run with the probation department. Same thing. So we're on, in addition to that, I think we've got all the scope and an opportunity to do it as discussed the case concept. As of late as yesterday, we're requesting a docket call, just laying on those columns. With the state. Recess.
Any objection? You available on October 13th?
Yes.
All right, court will set Mr. Lane in all cases for docket call on October 13th at 9 a.m. All right, the court's going to call the 10 o'clock docket. If I say your name, please raise your hand, say present or here. CR 27-3, State of Texas versus Jeffrey Berman. Record will reflect that Mr. Berman is appearing via Zoom today. All right, thank you, Mr. Sanders. I will recall that case in just a moment. State versus John Carmona. Rodolfo Gonzalez. All right, Mr. Carmona and Mr. Gonzalez, I need you to come over here and have a seat spread out in this jury box. I need you to discuss your pretrial release issues before I call your case. And Mr. Sanders, if you want to get with the pretrial release department, they can tell you the issues your clients are having. Yes, sir. And Mr. Sanders, before you do that, if you have any announcement on Mr. Berman, we can do that in just a moment.
Corrected judgments in progress.
Okay. Are you ready on Mr. Berman? Okay. All right, court calls CR 27-3, State versus Jeffrey Berman. And I believe we're set for docket call today, Mr. Sanders.
Yes, Your Honor, and we have a plea agreement. I'm going to ask that we can set it for a plea, maybe 3 or 4 weeks.
You available
He
on?
lives in Florida, so I'm kind of work around.
Okay. I've got October 13th or October 15th, and I've got something that's about a week and a half.
I'd say the 15th, that's a Thursday.
It's a Thursday.
15th.
Okay. All right. Then we'll set Mr. Berman for plea on Thursday, October 15th. Are you available at 9 a.m. that day, Mr. Sanders? And we'll set that at 9 a.m., Mr. Berman, okay?
9 a.m. October 15th?
Yes, sir.
Yes, sir.
That'll be the only notice that you receive from the court. Mr. Sanders may receive one, but you will not receive one from the court, okay? You're receiving it here in open court.
Excellent. I will be there. Yes, sir.
All right, thank you, Mr. Berman. You're free to go.
Thank you so much. Have a great day.
All right, Mr. Head. Mr. Broderick, want to try one more time, sir? All right, Mr. Broderick, I don't think I've placed you under oath yet, have I? All right, Mr. Broderick, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. You are Brandon C. Broderick, is that correct? And Mr. Broderick, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Mike Head. Are you pleased with his representation of you? You feel like you've had sufficient time to review each one of your cases with him and have all of your legal questions answered? Mr. Head, do you believe your client to be competent today?
I do, Your Honor.
You believe he understands and appreciates the nature and consequences of his plea agreement?
Yes, sir, I do.
Mr. Broderick, you are indicted with the second-degree felony offense of indecency with a child by exposure in both CR 1949 and CR 1950. A second-degree felony in the state of Texas carries a range of punishment of confinement in the Texas Department of Criminal Justice for a period of not less than 2 years nor more than 20 years and a fine not to exceed $10,000. Do you understand that range of punishment? That means any plea agreement you wish to enter with the state or any sentence handed down by the court must fall within that range of punishment. I understand that there is a plea agreement that you have reached with the state in each case, It appears that you're going to plead guilty to each one of these charges. In exchange, the state's going to recommend that your punishment be assessed at 12 years confinement in the Texas Department of Criminal Justice Institutional Division, with your time running concurrent with each sentence. In addition, you would have a zero fine, court costs in the amount of $290, and reimbursement fees of $110. In addition, you would be required to plead true to the enhancement paragraph alleged in the indictment, which increases the charge from a third-degree felony offense to a second-degree felony offense. Is that your understanding of the plea agreement, sir? At this time, Mr. Broderick, how do you plead in CR 1949 to indecency with a child by exposure? And in CR 1950, how do you plead to that same charge of indecency with a child by exposure? And Mr. Broderick, are you pleading guilty because in fact you are guilty of committing each one of those offenses? Has anyone threatened you, forced you, or pressured you to plead guilty to either one of these charges? All right, court will accept the defendant's plea of guilt. Mr. Head, any objection to the admission of States 1 stipulation of evidence?
No.
All right, court admits States Exhibit 1, the stipulation of evidence in each cause respectively, and takes judicial notice of Mr. Broderick's judicial confession. The court will also note for the record that the state has complied with the victim notification requirements, and the court has reviewed the victim impact statements and has that to return to the state. Anything further from the state?
No, just close.
Anything further from the defense?
No, Your Honor, rest.
And I failed to ask you, Mr. Broderick. I told you about it, but I failed to ask you. In the indictment, the state has alleged an enhancement paragraph. And have you reviewed that indictment and that enhancement paragraph with your attorney, Mr. Head? Do you feel like you need to do that again, just so that you understand? In CR 1949, the state alleged an enhancement paragraph, and I would need to know, Mr. Broderick, is that paragraph true or not true? True. And also in CR 1950, the state also included an enhancement paragraph in their indictment, and I need to know, is that enhancement paragraph true or not true? All right, court will accept Mr. Broderick's plea of true to the enhancement paragraphs included in the indictment. All right, Mr. Broderick, based upon the evidence before the court will find there's sufficient evidence to convict you of each one of these offenses, and the court will follow the plea agreement and recommendation of the state. In CR 1949, the court hereby convicts you of the second-degree felony offense of indecency with a child by exposure. Court finds the enhancement paragraph to be true. Court assesses your punishment in accordance with the plea agreement at 12 years confinement in the Texas Department of Criminal Justice, with that sentence to run concurrent with CR 1950. Court assesses court costs in the amount of $290 and reimbursement fee of $110. In that case, the court also awards you 229 days credit for time that you have spent in jail on that cause. CR 1950, court finds that there's sufficient evidence to convict you of that offense and convicts you of the second-degree felony offense of indecency with a child by exposure. Also assesses your punishment in accordance with the plea agreement at 12 years confinement in the Texas Department of Criminal Justice. Orders that sentence in time to run concurrent with CR 1949. Court assesses court costs in the amount of $290, reimbursement fee of $110, and issues you 229 days credit for the time that you have spent in jail on that cause. Court also finds that Chapter 62 applies to the defendant for convictions in each cause, and also finds that Chapter 62 of the Code of Criminal Procedure has been provided to the defendant. So you received a copy of that today from the defense or the state?
We did have a copy.
Mr. Head, I notice there's 2 trial court certifications. I think this one has got more updated information, so I'm just gonna, they're both the same cause number. This one just seems to be a pre-printed form, so I'm just gonna get rid of this one. All right, Mr. Broderick, you hereby remanded to the custody of the Van Zandt County Sheriff. Have you join my bailiff up here? Be fingerprinted, and then bailiff, Mr. Broderick's ordered into custody. Yes, thank you. I'm almost finished with that letter. Started it last week. You get to see this week. Sure. Needs to go with that paperwork. Thanks. All right, the court's going to call the 10:30 docket. If I call your name, please raise your hand, say present or here. Jonathan Kaufman. Mr. Kaufman, I need you to come have a seat in the jury box to discuss your pretrial release issues. Is Mr. Knoll here? There you are, Mr. Knoll. O'Darian McCray. Thank you, Mr. Knoll. All right, that's the 10:30. All right, do we have anyone else that's ready, Ms. Beasley? All right, Mr. Huggins. This is CR 2124, State versus Hunter, James Huggins. Mr. Huggins, if you will, raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, you are Hunter James Huggins, is that correct? And Mr. Huggins, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Ms. Deborah Beasley. Are you pleased with her representation of you? Feel like you've had sufficient time to review the case with her and have all of your legal questions answered? And Ms. Beasley, do you believe that Mr. Huggins is competent today? And you explained to him the advantages and also the disadvantages of a deferred adjudication plea? And you believe he understands the nature and consequences of that plea? Mr. Huggins, you are charged by indictment with the first-degree felony offense of aggravated robbery. That carries a range of punishment of not less than 5 years nor more than 99 years or life confinement in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. Do you understand that any plea agreement that results in your incarceration or any sentence handed down by the court could fall anywhere within that range of punishment? Now, understand that there is a plea agreement in this case in which you would be pleading guilty to that first degree felony offense, and the state's recommending that the court review the evidence, find that there's sufficient evidence to convict you of that offense, but that the court should defer a finding of guilt, place you on community supervision or probation for 8 years, along with a $1,600 fine, and ordering restitution in the amount of $3,000 to be paid along with your co-defendants to the alleged victim in this case. Is that your understanding of the plea agreement? Mr. Huggins, then, to the first degree felony offense of aggravated robbery, how do you plead? Guilty or not guilty? And are you pleading guilty because in fact you are guilty? Has anyone threatened you, forced you, or pressured you to plead guilty to something you're not guilty of committing? Ms. Beasley, any objection to the admission of States 1, stipulation of evidence? Court admits States Exhibit 1 and takes judicial notice of Mr. Huggins' judicial confession. Anything further from the state? Any victim impact statement or statement of whether or not they agree with this plea agreement?
We are in compliance.
Has the victim communicated to your office whether or not they agree or disagree or have had no contact?
Judge, we have contacted the victim.
Anything further from the defense?
Yes, Your Honor, that's upon your level of response.
Okay, go ahead.
We were here for previously, and we were intended to plead that time, but we changed some terms of the plea agreement. And back to work for today, correct? So we've had communications prior to these 2 days, we even before, talk about the case, talk about the evidence, police report, witness statements, people that range $5.99 a lot. And you can do everything strictly, you're everything you do for the party. Is that correct? And you're asking that for, read this. And I can only answer your question, that with your dad as well, we answer questions, and I believe that mom was here for today. And have we answered all of your questions? God, there's several things to make sure that you protect yourself.
Any questions from the state? Thank you, Ms. Beasley. All right, based on the evidence before the court will find there is sufficient evidence to convict Mr. Hunter James Huggins of the first-degree felony offense of aggravated robbery. However, the court will follow the plea agreement in this case. The court will defer a finding of guilt in this matter. Will place Mr. Hunter James Huggins on community supervision for a period of 8 years. Court assesses a fine of $1,600, restitution of $3,000 to be paid joint and several with co-defendants Jose Vela, Kirkland Huggins, and Gabriel Romero. Court also orders you to pay reimbursement fees in the amount of $1,285. Mr. Huggins, how old are you? 24? And I know that you have spent a lot of time speaking with your attorney because your attorney put your testimony on about that. And so tell me, what happens if you violate the conditions of your community supervision? Go to jail? You're wrong about that. There won't be no jail involved for you. You go to prison. And so how long could you go to prison? Or life? Life. It's a long time. You're 24. So that means if you drink alcohol, you smoke weed, you write a hot check, you don't do your community supervision, you don't report, any one of those things could bring you back before me. And if it's proven to me that you violate your community supervision, then it'll be up to me to decide how long you go to prison. And that? So for right now, you're the one that decides whether or not you go to prison. You're the one that decides that right now. That's based on whether or not you're going to do what you're supposed to do. If you transfer that decision to me, I'm going to make it. We clear? Mr. Huggins, you're hereby remanded to the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward and join the bailiff here to be fingerprinted. After that, you need to report to this back room to the probation department. Well, she's not on Zoom anymore, so. Yes. All right. O'Darian McCray. You know, you'll need to have these sworn by the clerk, so just take him across the hall and they'll need to be sworn on several documents there. Yes, Mr. Alton, how are you, sir? Doing good. Who are you ready on? Okay.
This Hoover is a county court of law case.
Okay, good. Okay, will do. Scotty Collins. All All right, Mr. Collins, if you will raise your right hand, I'm going to place you under oath, sir. Mr. Collins, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. You are Scotty Edward Collins, is that correct? Mr. Collins, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? And in this case, you're represented by your attorney, Mr. Gilbert Altum. Are you pleased with his representation of you? Do you feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered? Is there anything about this plea agreement that you have read and signed that you do not understand? All right, Mr. Collins, you were indicted with the state jail felony offense of possession of a controlled substance in penalty group 2, less than 1 gram. However, it appears that a plea agreement would reduce your charge to where it would be prosecuted under section 1244B of the Texas Penal Code, which would result in a misdemeanor conviction and punishment in accordance with a Class A misdemeanor offense, which would be confinement in the county jail for a period not to exceed 1 year and a fine not to exceed $4,000. Do you understand that range of punishment? So, Mr. Collins, I ask you at this time, how do you plead to the state jail felony offense of possession of a controlled substance in penalty group 2, less than 1 gram? Collins, are you pleading guilty because of the fact you are guilty? Has anyone threatened you, forced you, or pressured you to plead guilty to this offense? Mr. Altum, any objection to the admission of States 1?
Okay.
States 1's admitted into evidence. Court takes judicial notice of Mr. Collins' judicial confession. And I don't know if I asked you, Mr. Altum, but let me ask you this time. You do believe your client to be competent today?
I do, Your Honor.
Okay. Anything further from the state? Anything further from the defense? All right, Mr. Collins, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense. Court will follow the plea agreement. In this case, court convicts you under section 1244B of the Texas Penal Code of possession of a controlled substance in penalty group 2, less than 1 gram. Court assesses your punishment at 1 day confinement in the county jail. Court issues you credit for time served. Court also assesses a fine in the amount of $3,500 and restitution in the amount of $180. In addition, the court orders you to reimburse Van Zandt County for $35. And Mr. Collins, are you paying your fines and fees today? And if you set up a payment plan and you do not follow through with that, do you understand what happens? And what is that? Yes, sir. And does it do you any good to sit in jail? And it doesn't do Van Zandt County any good for you to sit in jail. So make every effort that you can to comply with the payment plan that we're going to extend to you. Okay? All right, Mr. Collins, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you step forward with my bailiff to be fingerprinted, after which I want you to report to the court collections officer at the end of the hall on the left, Ms. LaPrade. Okay. Mr. Runner Leader? Yes. Delaney? Is she in the courtroom or?
She's right outside.
Okay, and what's the issue with Miss Delaney? No, that's okay. Let's go off the record for a second.
So, Your
Is this
Honor,
the one y'all wanted to talk about before?
yes. So she, right before court, she checked with me that she was, jumped last night along with her boyfriend.
And in this case, you're represented by your attorney, Mr. Gilbert Altum. Do you feel like you've had sufficient time to review your case and have all of your legal questions answered by him? Are you pleased with his representation of you? Mr. Altum, do you believe that your client is competent today? And you've explained to her her legal and constitutional rights?
Yes.
Ms. Schubert, you are charged by information with a Class A misdemeanor offense of possession of a controlled substance in penalty group 3 less than 28 grams. The range of punishment for a Class A misdemeanor is confinement in the Van Zandt County Jail for a period not to exceed 1 year or a fine not to exceed $4,000. Do you understand that range of punishment? At this time, how do you plead to that Class A misdemeanor? Are you pleading guilty because in fact you are guilty? Has anyone threatened you, forced you, or pressured you to plead guilty? All right, court will accept Ms. Schubert's plea of guilt. Is there any objection to the admission of States 1, Mr. Alton? States 1 is admitted into evidence. Court also takes judicial notice of Ms. Schubert's judicial confession. Anything further from the state? Anything further from the defense? All right, Ms. Schubert, based on the evidence before the court will follow the plea agreement in this case. The court hereby convicts you of the Class A misdemeanor offense of possession of a controlled substance in penalty group 3, less than 28 grams. Court assesses your punishment in accordance with the plea agreement at 13 days confinement in the Van Zandt County Jail. Court issues you credit for 13 days time already spent in jail. Court assesses fines in the amount of $480 and court costs in the amount of $270. Is Ms. Schubert paying her fines and fees today, Mr. Alton? And does your client understand that if she fails to pay as ordered, that a warrant will be issued for her arrest? Ms. Schubert, you understand that? Immediately upon being released from the courtroom, I want you to report to the court compliance officer at the end of the hall on your left. All right, Ms. Schubert, you're hereby remanded to the custody of the Van Zandt County Sheriff's Office so they can carry out terms and conditions of your sentence. I'm going to have you step forward with the bailiff, be fingerprinted. After that, head on down to the court collections officer. And then you'll be free to go. No, it's she's got Tom Sawyer's, I believe. Oh, does she? Oh, it's going to be, yeah, it does take care of that. Okay, so state, the court had a note that there was a bond forfeiture warrant on this case. However, this does resolve all of Ms. Schubert's issues with the state. Is that correct? Was it on this case? And so Ms. Schubert doesn't have any further pending charges? Okay, so we'll need to do a motion to withdraw that. If you can help me with that. Motion to withdraw the forfeiture warrant. And so no, bailiff, she will not go into custody. Yes, sir. Thank you. Appreciate it. Court's going to call the 11 o'clock docket. Jacob David Howell. Thank you, Mr. Howell. Kevin Lee Wood. Kevin Lee Wood. Is Mr. Adams here? Does anyone see Mr. Adams? Is he in the hallway working? He was? Okay. He may be working with him then on plea papers. All right. Mr. Knoll, you ready? Mr. McCray? All right, are you O'Darian Dwayne McCray? Mr. McCray, if you'll do me a favor, raise your right hand. I'm gonna place you under oath. Mr. McCray, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. You may put your hand down, sir. All right, Mr. McCray, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Kurt Knoll. Are you pleased with his representation of you? Do you feel like you've had sufficient time to discuss your case with him, have all of your legal questions answered? Mr. Knoll, do you believe your client to be competent today? and you explained to him all of his legal and constitutional rights?
I have, Your Honor.
It appears that there's a plea agreement in this case wherein Mr. McCray will be pleading guilty to a first-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 200 grams but less than 400 grams. Mr. McCray, the range of punishment for that level of offense is confinement in the Texas Department of Criminal Justice Institutional Division for a period no less than 5 years or more than 99 years or life, and also a fine not to exceed $10,000. Do you understand that range of punishment? And in this plea agreement, it appears that in exchange for your plea of guilt, the state's recommending that your punishment be assessed at 20 years confinement in TDCJ, restitution of $360, court costs of $290, $55 reimbursement fee. In addition, the state would be dismissing under section 1245, cause number CR 2217, possession of controlled substance in penalty group 1 greater than or equal to 400 grams, and then 3 unfiled misdemeanor cases, 2 unfiled misdemeanor cases, possession of marijuana, unlawful carrying of a weapon, and what appears to be an unfiled felony case of tampering with physical evidence. Mr. Knoll, is that your understanding of the plea agreement?
It is, Your Honor.
And Mr. McCray, is that your understanding as well? Mr. McCray, I'll ask you at this time, how do you plead to possession of a controlled substance in penalty group 1 greater than or equal to 200 grams but less than 400 grams? And Mr. McCray, are you pleading guilty because in fact you are guilty of that offense? Has anyone threatened you, forced you, or pressured you to plead guilty to this offense when in fact you're not guilty? All right, the court will accept Mr. McCray's plea of guilt. Mr. Knoll, any objection to the admission of States 1?
No, Your Honor.
States 1 is admitted into evidence, and the court takes judicial notice of Mr. McCray's judicial confession. Is there anything further from the state, Mr. Cox?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Is there any agreement on the disposition of the weapon that was seized in this offense?
Judge, we did not bring that up.
I believe there's a document in there that indicates that it would be confiscated, not necessarily destroyed.
Where's that at? It's usually in the judgment. I don't see it here.
It's a separate document.
I'll let you show me. I got you. Yeah, this is just an inventory. This is actually a return on a warrant, I think. Inventory of property seized.
I think this is. Anything's confiscated.
Okay. I remember that. It was done back in April. Looks like they submitted it maybe without knowing if the case had been resolved. I believe they sent over a whole list of cases. So I want to talk to Ms. Curry about that.
Okay.
Otherwise, they may be destroying your evidence. Thank you, Mr. Knoll. All right, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense, Mr. McCray. Court does convict you of the first-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 200 grams but less than 400 grams. Court assesses your punishment in accordance with the plea agreement at 20 years confinement in the Texas Department of Criminal Justice Institutional Division, orders you to pay $360 restitution. Court orders you to pay court costs of $290 and a $55 reimbursement fee. The court dismisses under section 1245 of the Texas Penal Code, CR 2217, possession of controlled substance, penalty group 1, greater than or equal to 400 grams. Court also dismisses unfiled possession of marijuana, M19-224, unlawful carrying of a weapon, M19-223, and tampering or fabricating physical evidence, DA 2020-64. Court awards you 96 days credit for time that you have spent in jail on this cause. Mr. McCray. And Mr. Knoll, on the trial court certification of defendant's right to appeal, nothing was checked here. And so I checked off that this is a plea bargain case and the defendant has no right to appeal.
That was explained.
All right, Mr. McCray, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step forward here with my bailiff to be fingerprinted. And then after which time you'll be taken into custody. And bailiff, I'm sorry. I should have handed you that as well. You ready, Mr. Kaufman? Mr. Kaufman, if you come on over to the podium. Have you met with the probation department yet? Okay, just come on over to the podium. CR 2207, State versus Jonathan Lamar Kaufman. And I believe that we are set for arraignment in CR 2207 and pretrial in CR 275. Is that correct, Mr. Knoll?
I believe that is, Your Honor, if I could, I guess taking the second case with regards to the continuing violence. State had made an offer of 12 years on that case. That was relayed to Mr. Kaufman. Kaufman had some political exchanges by way of text messages. The state then filed a Brooks notice, which raised the punishment on that 25 to life. Memory serves me correctly, after that, they then indicted the second-degree felony drug case. It is set for arraignment here today. I don't have any discovery yet on that case, which also obviously should be enhanced to 25 to life as of now. It has not been yet. In reference to the continuing violence in the family, I have reviewed all the discovery in the case. Mr. Kaufman has defined 4 or 5 videos. Videos, at different points in time, statements made by the victim to law enforcement. I've explained the issues involving should a witness fail to appear, the subpoena issue, the issues if a witness changes their story on the witness stand, how that is handled. So, again, Mr. Hoffman has seen 0 and declined to meet to discuss these continuing violence, which now has a range of 25 to life, unless the state decides not to pursue the principles.
But you've not reviewed the indictment in the new case. Have you been appointed to represent him in the new case? Okay, if you'll,
And I have a copy, although my copy, I assume the state did file, e-file, because my copy of the first notice is not, does not have e-file. Although I have a copy.
It should be fine.
I'll review this and I guess, unless Mr. Hoffman has finally retained other counsel as he says he's going to.
all right, Mr. Kaufman, in CR 2207, the Van Zandt County Grand Jury has returned an indictment that reads, the grand jury for the county of Van Zandt, state of Texas, duly selected and paneled, sworn, charged, and organized as such at the January term AD 2020 of the 294th Judicial District Court for said county upon their oaths present in and to said court at said term that Jonathan Lamar Kaufman, hereinafter styled defendant, on or about January 27th, 2020, and before the presentment of this indictment in the county and state aforesaid, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, in an amount of 1 gram or more, but less than 4 grams, signed by the foreman of the grand jury. And your name has been spelled Jonathan, middle name Lamar, Lamar, last name Kaufman, Coffman. Is your name spelled correctly in that document? It is? And this indictment is for a 3rd-degree felony offense located in the Health and Safety Code, which carries a range of punishment of not less than 2 years nor more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. The state has also filed a Brooks notice, which is an enhancement instrument alleging that based on what they're alleging to be your prior convictions, that the range of punishment in this case could be elevated upon a finding of guilt in this case to that of habitual felony offender status, which would be confinement in the Texas Department of Criminal Justice for a period not less than 25 years or more than 99 years, or life confinement in the Texas Department of Criminal Justice. Do you understand that range of punishment? And at this time, do you enter a plea of guilty or not guilty in that cause? All right, the court will have the record reflect that this defendant has been formally arraigned, his name is spelled correctly in the indictment, and that he has entered a plea of not guilty into the record. Now, regarding the second case in which Mr. Kaufman has not reviewed the discovery, Mr. Knoll, that's Mr. Kaufman's right. He doesn't have to review discovery. As long as it's been made available to him, then I believe the state's in compliance with their Brady and Morton requirements.
There are five videos on that.
Do you have any pretrial motions in that case, Mr. Knoll?
No, Your Honor.
All right, so what we'll do is we'll set Mr. Kaufman's continuous family violence case. We'll set that for docket call on October 13th. And on that same date, we'll set Mr. Kaufman's possession of controlled substance case for pretrial on October 13th. Are you available on each one of those days or that day? And we'll set that at 9 a.m. And if there's such a time that Mr. Kaufman wants to retain his own counsel, then he'll retain counsel, and that counsel will file a motion to substitute an appearance in the case. Otherwise, that matter is not before the court. You understand, Mr. Kaufman? All right, Mr. Knoll, if you'll have notice of settings filled out from Mr. Kaufman indicating those case numbers with those dates, he'll retain the yellow copy. I'll retain the white copy. And then Mr. Kaufman, you'll stay over here and have a seat, and probation will speak with you about your pretrial release violations. Or not violations, but insufficiencies, we'll say at this point. Mr. Manning, are you ready?
I believe Mr. Zanella is appearing ready. I'll just want to incorporate that he was in the lobby.
Yes, sir. So he's already filled out all the paperwork and you signed it. Then you'll go out there with him. Yeah, you'll go out there with him and then they'll send all that paperwork back.
So just take it.
Yeah, well, if you've got it and it's all signed, you can leave it here. I'll keep it here and then we'll go through it this afternoon. He's already signed it, reviewed everything. Yeah, leave that here with me and then we'll do the plea out there. Right, I don't see Mr. Oh, let me see if he's back in.
Well, I just received a text message from my office that he just had his son die. And he's seeking to get we're announcing already, proceed to jury trial. We have another announcement beyond that fact.
We'll need to get him either on record in Zoom or he needs to appear.
It's just, I'm also ready on Mr. Long.
Ronald Keene,
Yes.
make your way to the podium, sir. Have you signed your pretrial release papers?
Did we have a brief time to take that?
Hang on, Mr. Manning. Has he signed his pretrial release papers?
Did she have those? I got one question for the nurse.
Okay, what's that?
Judge, on here it's marked numbers 4 and 5 that should stay away from the victim not to be paid. The victim in this case is filed an affidavit of prosecution. Furthermore, she's been living with the defendant ever since.
You'll need to file that as a motion.
Then I spoke to the state, they're not opposed to removing those conditions. And I talked to Ms. Byrne, and she said that you could intervene.
Okay, so there's an agreement then.
Yes.
What does that mean? What does that mean?
Means the state takes no position. We've been made aware that the victim does not wish to prosecute, does wish that condition be removed.
Okay. Yes. On King?
Grant those victim impact statements.
Oh, yes. So the only amendment you were asking for was the assault case, not the DWI case. Okay, all right. I've amended those.
With that, we would like to reset Mr. King for a plea. Next available, so maybe have some for that.
If you might need to write them amended up there so we can keep track of it. All right, so you're asking for a plea on each case?
Yes,
All right, so there's no contested pretrial matters. Court will set this for plea, and is there a certain amount of time you're looking for?
just regular ones.
All right, we'll set this for plea on October 13th at 9 a.m. All right, once Mr. King gets the yellow copy, white copy stays with me, you'll be free to go. You're welcome, sir. Make sure you get this notice before you go. Mr. Manning, did Mr. Cooper?
Judge, I believe, say that's announcement on that.
Go ahead.
Your Honor, on Mr. Cooper's case, we will be withdrawing that motion that we previously filed after reviewing the court's the rules. We no longer believe that that motion is appropriate. However, I asked Mr. Manning to make sure that we have contact with Mr. Cooper because he was not here this morning because there was some difficulty getting hold of him. I asked just that we make sure that we have a good way to contact him so he does appear in future settings, even though I am withdrawing my motion on this.
Is he set for something other than motion to?
Yeah, there's not something unindicted.
Oh,
He does not have an informal set.
okay, so okay. So the court only had jurisdiction by virtue of the writ. All right, so there's nothing else pending in the court at this time. Okay, okay.
Once it gets completed, I've received information, Mr. Snell may be back.
All right, we're waiting for Mr. Zanella's phone to connect to audio. All right, Mr. Zanella, you may want to unmute your phone there. You have to find that red microphone button. This is CR 19-294 State versus Francisco Zanella. We're set for docket call today, Mr. Manning.
That's correct, Judge. We're just ready. We asked for a hearing copy.
All right, and Mr. Zanella understands that the rejection of any offer or failure to negotiate any counter plea offers may not be entertained by the state or may not be entertained by the court after the passing of today's docket call.
You've extended to previously when he was here, and as well as I.
Okay. All right. So the court will set Mr. Zanella then for jury selection. Here's our next jury selection. All right, I'm gonna put in that group, I think. All right, set Mr. Zanella for jury selection on October 26th. This case will not be reached for trial that day. However, that's when he'll begin hearing on the monthly trial docket. So Mr. Zanella, you'll need to report to the basement of the courthouse. You will not be in the courtroom. And once you report down there, there will be a staff member there to assist you with further paperwork and notice of settings with new dates. You understand?
Yes, sir.
And the record will reflect that Mr. Zanella is appearing via Zoom today. All right, Mr. Zanella, that's the only notice that you're going to get from the court is here on Zoom in open court that you're ordered to appear on October 26th by 9 a.m. in the basement of the courthouse. All right?
That's okay.
All right. Mr. Manning, anything further?
I believe that is on this assessment.
All right, Mr. Zanella, you're free to go.
Okay, thank you, sir.
Mr. Adams, are you ready?
Yes, Your Honor.
Who are you ready on?
Both Mr. Wood and Mr.
Either one of those a plea? Yes, let's go and do the plea first. How's it going today? Good. Kevin Lee Wood. Mr. Wood, if you'll make your way to the podium, please. Ms. Beasley, I'm going to need to. Mr. Wood, if you'll raise your right hand. Mr. Wood, you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Please put your hand down there. You are Kevin Lee Wood, is that correct? And Mr. Wood, are you a United States citizen? Do you read, write, and speak English? Make sure you speak up loud so my court reporter can hear you, okay? And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you? Do you feel like you've had sufficient time to talk to him about your case and have all of your legal questions answered? Mr. Adams, do you believe your client to be competent?
He's competent, Your Honor.
And you've explained to him the advantages and disadvantages of a deferred adjudication community supervision?
That's correct, Your Honor.
Mr. Wood, you've been indicted with the second-degree felony offense of possession of a controlled substance in penalty group 1, 4 grams to 200 grams. That carries a range of punishment of confinement in the Texas Department of Criminal Justice for not less than 2 years, nor more than 20 years, and a fine not to exceed $10,000. Do you understand that if you are ever sentenced by this court to the Texas Department of Criminal Justice, the court, based on the deferred adjudication community supervision, could assess your punishment anywhere from 2 to 20 years in prison? You understand that? I'll ask you at this time then, Mr. Wood, how do you plead to that second-degree felony offense? And Mr. Wood, are you pleading guilty because you are guilty of that offense? Has anyone threatened you, forced you, or pressured you to plead guilty to this offense? All right, the court will accept Mr. Wood's plea of guilt. Mr. Adams, any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Anything else from the state? Anything further from the defense?
No, Your Honor. That's my support.
All right, Mr. Wood, based on the evidence before the court finds that there is sufficient evidence to convict you of this offense. Court will follow the plea agreement in this case. The court hereby defers a finding of guilt, places you on community supervision for a period of 5 years, assesses a $2,500 fine, orders you to pay restitution of $180, court costs of $290, reimbursement fees $935. Mr. Wood, have you ever been on probation before? A long time ago? Did you complete it or did you get revoked? And do you understand that violating the terms of your community supervision could result in you being brought back before the court? And if the state proves to the court that you violated your community supervision, court could adjudicate you, that means convict you of this offense, and also assess your punishment, as you and I have already discussed, anywhere between 2 years and 20 years. That's a big range of punishment for the court. That's the disadvantage. That's the disadvantage of deferred community supervision. And you told me that you've understood that. So right now you get to decide whether or not I decide what happens to you. You get to decide that right now. But as soon as you violate your community supervision by drinking, smoking weed, doing any drugs, not reporting, not doing your community supervision, not paying your fees, not doing any of that, as soon as you do that, then that decision reverts back to me. Do you understand that? All right, Mr. Wood, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you step forward here, be fingerprinted with the bailiff. After that time, you're to report back here to the probation department. Jacob Howell. This is CR 28-3. We're set for pretrial, Mr. Adams.
Yes, you are. I was provided some additional discovery by the state, either Friday or since Friday. It's materials that I have not been able to review yet. I was in a hearing yesterday in other counties. So I'm asking for the court's indulgence to reset our pretrial to a later date to give me time to review the discovery that I've acquired and to determine what I need to do for our next pretrial.
What's the nature of the discovery?
Written materials, the bookend sheet, defense reports, all that good stuff.
Okay.
I tend to think that the audio video portion of the discovery may be made for me over the DA's office in the DVD format. I don't know for sure. I know that I do have some of that type of discovery for some of my cases waiting for me. If not, I'll pester Mr. Cox or Ms. Heisel about that.
State, do we know if there's digital evidence for Mr. Howell's case?
Oh, I'm sorry, no, there is. There is, and I just sent it to the discovery board.
All right, court will set Mr. Howell then for additional pretrial on October 13th, if you're available on that date. If not the 13th, and the 15th is available.
It is available, Your Honor. 13 is fine.
Mr. Knoll, do you have more on the docket?
With, Mr. Kaufman is in there, the state has indicated, and I gave it to Mr. Kaufman earlier, the state has indicated that on Mr. Kaufman's 2 cases, that he can plead to either case for 12 years. Obviously,
Well, I don't want to engage in y'all's plea negotiations. I just need to know, I've already reset him. Is there something that needs to be put on the record?
that he has until the 13th to accept one and I'll put the 5 years. Doesn't have about 13th, but we know.
Okay, and so you can communicate that to Mr. Bob.
He
If
has it in writing.
he has it in writing? Okay. And then on that date, if there's no plea agreement, then you can put that on the record then. Okay. All right, Mr. Howell, you're free to go.
Your Honor, I think that's all I have on the morning count today. Let's see what's coming up.
And Mr. Howell, I'm sorry, did you report to pretrial release regarding your pretrial release payments? Did you ever report to Ms. Burns back here? Okay, yeah, if you'll just make sure that you go over to pretrial release today and pay that. Yeah, you can go over to their office over there. Okay, you're free to go. Thank you, Mr. Howell. That's all you have, Mr. Adams? Mr. Hyde, you say you were ready? Mr. Sanders, Mr. White, are y'all also ready? Okay, go ahead, Mr. Hyde. Cruz Martinez. Are y'all asking for another plea date? Yes, let's be on the record. This is CR 19-181, CR 2054, Cruz Martinez.
Judge, Mr. Martinez, he was indicted first for the felony possession of firearm. I never made Mr. Hyde an offer on that because I was waiting for the lab on the PCS case. The lab came in on the PCS case, he was indicted on the PCS case. I never made an offer on either case. I don't know why, but I did not make Mr. Hyde an offer until yesterday.
How did we get set for plea then? If there was no plea agreement? Oh, it's okay. So there is a plea agreement now?
No, there is an offer.
There's an offer now. Let me take a moment and look at what we need to set this for. Let's see, we had a pretrial in July, and then we had a plea on 8/4, and then we had a plea today. So we'll set him for docket call. And if there's no plea agreement by docket call, then we'll set him on the trial docket. So we'll set this. Are you available on October 13th, you said? Okay. We'll set this for October 13th. Do you need something later in the morning? Like 11? 9? Okay. Okay, we'll set Mr. Martinez then for docket call in each case for October 13th at 9 a.m. All right, Mr. Martinez will get the yellow copy. I'll get the white copy once it's signed, and then he'll be free to go. All right, and then you'll have the plea this afternoon. I've got that 1:30. I'll knock you out first. All right, Mr. Sanders, Ms. Beasley, Mr. Murleader. You ready on what? You ready on what? Who's got a plea? Let's go with Mr. Sanders. You've already pled somebody out today, haven't you? You've already pled someone out today, haven't you?
Yes, sir.
She's gonna beat you, Jeff. She's gonna beat you, Jeff. She said she's doing 3 times the work. Rodolfo Gonzalez. Right there, Mr. Gonzalez. All right, Mr. Gonzalez, raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, please put your hand down. There you go. Mr. Gonzalez, you are Rodolfo Gonzalez, correct? And are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, your attorney, Mr. Jeff Sanders, are you pleased with his representation of you? Feel like you've had sufficient time to discuss your case with him and have all your legal questions answered? And Mr. Sanders, do you believe your client to be competent? And you've explained to him the nature and consequences of his plea agreement? Mr. Gonzalez, you were charged by indictment with the second-degree felony offense of burglary of a habitation. However, it appears that there's a proposed plea agreement for a Class B misdemeanor offense of criminal trespass. A Class B misdemeanor carries a range of punishment of confinement in the county jail for a period not to exceed 180 days and a fine not to exceed $2,000. Do you understand that any plea agreement or sentence by the court must fit within that range of punishment? Mr. Gonzalez, at this time, how do you plead to a Class B misdemeanor offense of criminal trespass? And Mr. Gonzalez, are you pleading guilty because in fact you are guilty and for no other reason? Are you pleading guilty because you're guilty of this offense? You're not pleading guilty just to get a good deal and quit having to come to court, right? Has anyone threatened you, forced you, or pressured you to plead guilty to this offense? All right, and let the record reflect that Mr. Gonzalez said no. The court hereby accepts Mr. Gonzalez's plea of guilt. Mr. Sanders, any objection to States 1? States 1 is admitted into evidence. The court takes judicial notice of Mr. Gonzalez's judicial confession. Anything further from the state? From the defense? Tell them that they need to go out the other way, probably. I mean, until probation or whatever. Or something. Ms. Heisel, is there any communication from the victim as to whether or not they support or don't support the plea?
Your Honor, I know we are in compliance, but do not believe that there have been communications. There are two co-defendants in this cause, and both of them have already pledged, I believe, in restitution. The fact for us is that Mr. Gonzalez was in the vehicle, but did not participate in the burglary.
Okay, that's sufficient. All right, Mr. Gonzalez, based on the evidence before the court will follow the plea agreement in this case. The court hereby convicts you of the lesser included offense of criminal trespass at Class B misdemeanor, assesses your punishment at 2 days confinement in the county jail, issues you credit for time served, assesses a fine of $1,000, court costs of $270, and orders you to reimburse Van Zandt County $840. And when are you going to be able to satisfy all the money that you owe Van Zandt County?
For the most likely by next week.
By next Friday? All right, Mr. Gonzalez, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. Mr. Gonzalez, I'll have you step forward, be fingerprinted with the bailiff, after which, since you're not paying in full today, I want you to go down and see the court compliance officer. And you can let her know, you'll need to set up a payment plan, and then if you can pay it off by next Friday, then I would advise you to do that. Okay, step up here to your left. Thank you. Are you ready on Mr. Carmona?
Yes,
Mr. Carmona? CR 2043, set for pretrial today.
Yes, Your Honor. I think we set for pre-trial a couple weeks ago. He was in, I think, the Dallas County or Franklin County jail, so we set for today for status. Obviously, he's out now. Still don't have any pre-trial issues. We do have the discovery, and we just go ahead and set for docket call.
You available on October 13th or 15th?
Yeah.
All right, court will set this for docket call on October 15th at 9 a.m. Do you want me to continue setting these for these adjusted hours? If they're appearing at 10, do we have them come back at 10 the next time? Or okay, I haven't been doing that on very many, so, but I'll start doing that. Mhm. I don't think they can record it, but I think they could put a link. I mean, they can tell people where to find it. Yeah, because if I let them record it, then let everybody record it. All right. Okay. All right, Mr. Carmona, you're free to go. And you've met with pretrial release and discussed your paperwork? Excellent. Thank you, sir. All right, Ms. Beasley, you ready?
Yes, Your Honor. On both cases.
Let's do it. Which one's first? I don't.
Rosalind Taylor, Your Honor.
Ms. Taylor? It's a CR 2142, State versus Rosalind Burnett Taylor. All right, Ms. Taylor, if you'll raise your right hand. Ms. Taylor, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
All right, you may put your hand down. You are Rosalind Burnett Taylor, is that correct?
Yes, sir.
Ms. Taylor, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
I've been diagnosed with bipolar disorder and manic depression.
Are you currently on medication for either one of those?
Yes, sir.
And do you feel like that medication is assisting you today?
Yes, sir.
Feel like- Okay, you feel like you have clarity of thought and you understand the proceedings today?
Yes, sir.
All right, thank you. And your attorney is Miss Debbie Beasley. Are you pleased with her representation of you?
Yes, sir.
Do you feel like you've had sufficient time to discuss your case with her and have all your legal questions answered?
Yes, sir.
Ms. Beasley, do you believe Ms. Taylor to be competent today?
I do, Your Honor. She did spend some time at the state hospital, but I've talked with her since then, and she is clear of thought, clear of mind. I just believe she is competent.
And you've explained to her her legal and constitutional rights?
I did, Your Honor.
Ms. Taylor, you were originally indicted with the second-degree felony offense of burglary of a habitation. However, it appears that there is a plea agreement in which you would plead guilty to a lesser included Class A misdemeanor of criminal trespass of a habitation. A Class A misdemeanor carries a range of punishment of confinement in the county jail not to exceed 365 days or a fine not to exceed $4,000. Do you understand that any plea agreement or sentence handed down by the court must fall within that range of punishment?
Yes, sir.
And it looks that, it appears to the court that you're going to plead guilty to that lesser offense of criminal trespass of a habitation in exchange for the state's recommendation that your punishment be assessed at 98 days confinement in the county jail, credit for 98 days of time that you have served on that case, a $100 fine, and then several cases would be dismissed, including a criminal mischief, interference with emergency request for assistance, assault causes bodily injury, family violence, and assault against the elderly or disabled individual. Is that your understanding of the plea agreement, Ms. Taylor?
Yes, sir.
Yours as well, Ms. Beasley?
Yes, Your Honor.
Ms. Taylor, to the Class A misdemeanor offense of criminal trespass of a habitation, how do you plead?
Guilty.
And you plead guilty because in fact you are guilty?
Yes, sir.
Okay. Has anyone threatened you, forced you, or pressured you to plead guilty to that?
Yes, sir.
Court will accept Ms. Taylor's plea of guilt. Ms. Beasley, any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence, and the court takes judicial notice of Ms. Taylor's judicial confession. Anything further from the state?
Briefly, Judge, court's information for the record on the 21st of August, Ms. Cheney from our office reached out to the victim. She stated that she did not want to be involved in this case, so we have reached out to her. And, yeah, done our due diligence.
Thank you, sir.
If I may, Your Honor, Taylor is actually now involved in a movie program in Cedar Hill. So she's in a different environment and getting her life on track and is aware of the fact that she needs to basically stay away from her family.
All right, based on the evidence before the court, Ms. Taylor, the court will follow the plea agreement in your case. Court convicts you of the lesser included offense, Class A misdemeanor criminal trespass of a habitation, assesses your punishment in accordance with the plea agreement at 98 days in the county jail. The court gives you credit for 98 days of time already served. Court assesses a $100 fine, and the court orders you to pay reimbursement fees in the amount of $1,010 and court costs in the amount of $270. and the court dismisses the unfiled misdemeanor cases included in the judgment. Ms. Taylor, you understand that if you're not able to pay your reimbursement fees and your court costs and your fine immediately, then you'll need to meet with the court collections officer and make a payment plan. And you'll need to be diligent about making your payments. If you don't, there's going to be a warrant that's going to issue for your arrest, and you.
I'm on disability as well, and I have to pay my rent to her as well. After I get to pay my rent, $100-something.
I understand. You're just like everybody else. We all got bills, right? We all got to pay. So I'm telling you that if you don't make a good faith effort to pay what you can afford to pay, which the court compliance officer will work out with you, if you just turn your head at it, put your head in the sand, you don't do anything, there's going to be a warrant for you, and you're going to end up right back where you are.
Yes, sir.
Okay. All right. You're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence, and have you come forward to be fingerprinted with the bailiff. After which, do we have a card from Miss LaPrade? Do we have another? Here's one right here. Do you have any more?
I just have one on Zoom.
Ms. Borchardt?
He says she can see you and can hear you.
Yes. But I cannot see her. Let's.
My video is not working.
There it is.
Oh,
Ms. Borchardt, can you turn your video on?
I am trying to. I can hear you. Can you hear me?
I can.
So my laptop apparently is not going to be able to do the video.
Okay, you are Daniel Borchardt, is that correct?
Yes, sir.
Okay, and what do we set for today, Ms. Beasley, pretrial?
I believe that is correct, Your Honor. I've been in discussions with Ms. Michael in regards to this case, and we're hoping based on the plea of the co-defendant to resolve Ms. Borchart's case. So with the court's permission, if we could reset Daniel Borchart's case to October the 20th, this case may be finally resolved. And we asked that since she also lives in Florida, that she could appear again by Zoom. With the court's permission.
That's correct, Your Honor. If we have a specific reason, we are not put on the record as to why we're requesting that date, we'd be happy to share with the court off the record. But I do believe that we will have this case resolved by that date. So I have no objection to her hearing by Zoom to resolve that matter.
No contested pretrial matters?
No, Your Honor.
All right, court will set Ms. Danielle Borchart's case on October 20th at 9 a.m. And the court will grant her permission to appear via Zoom. Perhaps we can get our video issue worked out, Ms. Borchardt, next week. It's not fair that you get to see me and I don't get to see you. That will be October 20th at 9 a.m. So this is the only notice that you're going to get from the court, okay?
Yes, sir.
All right, Ms. Beasley may send you one, but this is all you're going to get from me. So October 20th and appear via Zoom on Docket call. If nothing,
Okay.
You're free to go, Ms. Borchardt.
Thank you, sir.
You're welcome.
May I be excused?
Yes, ma'am. Thank you. Mr. Murley, are you ready? Lacey Tucker, CR 2092. Ms. Tucker is set for pretrial today. Are there any contested pretrial? Have you received discovery and an offer?
Yes, Your Honor, and offer is 45 days in jail, under 44 days, and a $2,500 fine. Ms. Tucker has accepted that, and she requested that she report for jail in October the
the state has agreed in exchange for a waiver of jury trial, which we have executed, which I can present.
Yes, you see that. All right, so you're asking the court to set it for plea in October,
October 13th, at 1:30.
October 13th. All right, Ms. Tucker, if you'll raise your right hand, I'm going to place you under oath. Ms. Tucker, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. You are Lacey Tucker, is that correct? And Ms. Tucker, you are represented by your attorney, Mr. Shravnes Muraliter, is that correct? And you and he have discussed and executed a waiver of jury trial form that I hold in my hand. And this waiver of jury trial tells me that you do understand that you have the right to have your case tried before a jury of your peers. And during that process, you have the right to confront the state's evidence and witnesses that may be brought against you. You understand that? You understand that no one can deprive you of that right to jury trial. However, you can waive that right if I find that you understand that right and that you are intentionally, knowingly, and voluntarily asking the court to allow you to waive that right. And at this time, Mr. Muraliter has indicated that you want to accept a plea agreement with the state. And part of that agreement is that you would waive your right to jury trial. Is that right? And so today, are you doing this of your own free will and accord? Okay, no one's threatened you, forced you. Mr. Muraliter hasn't told you you have to do this. And Mr. Cox or Ms. Heisel haven't told you have to do this? Okay. All right, court will approve the waiver of jury trial and we'll set Ms. Tucker for plea on October 13th at 9 a.m.
We're asking for 1:30 so she can go straight.
Oh, I'm sorry. Yes, that'd be fine. October 13th at 1:30. Thank you, Mr. Muraliter. All right, once she gets her notice, she'll get the yellow notice. I keep the white notice, and then she's free to go. And we did confirm that, well, let's do a reset on Vanderlinden. We confirmed that he's in the Tarrant County Jail. Let's set him for a status on 1013 as well. Do you have anything else that morning? Okay, then we'll just set that at 1:30 as well. If he gets out, then he can come out to the jail at 1:30. That way you don't have to make a morning trip. You fine with that? Mr. White, are you ready? Nicholas Fincher.
Your Honor,
Just one moment. Go ahead, Mr. White, I'm sorry.
Your Honor, this pre-trial, don't have any contested motions. I believe that we will probably have this thing resolved, the next time we come to court.
Let's come back tomorrow.
Well, that might be a little bit too quick, but I was thinking more in line for Thursday.
Okay. Court will set Mr. Fincher then for docket call on October 13th and find that there are no contested pretrial matters at this time. Mr. Fincher will get the yellow copy. Court will retain the white copy. Yes, he's free to go. Mr. Fincher, before you go, you did sign your conditions of pretrial release today, right? Did you go and speak with the probation department and sign your pretrial release conditions? Okay, come on back here and we'll go through this door and tell him you need to sign your pretrial release papers. Sorry, I should have caught that sooner. Is Montreal Mackey here? Good. This is CR 2032, set for docket call today, Mr. White.
Well, actually, please.
Oh, good. All right, Mr. Mackey, will you raise your right hand, sir? I'm going to place you under oath. Mr. Mackey, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Mackey, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you? Feel like you've had sufficient time to talk to him about your case and have all your legal questions answered? Mr. White, do you believe your client to be competent? Thank you, Mr. White. And Mr. Mackey, you were originally charged with a felony offense of possession of controlled substance, penalty group 1 greater than or equal to 400 grams, but there appears to be a plea agreement in which you would be pleading guilty to a lesser charge, a state jail felony offense of possession of a controlled substance, penalty group 1, less than 1 gram. And furthermore, that case would be prosecuted under section 1244A. The range of punishment for a 1244A state jail felony is confinement in the Van Zandt County Jail for a period not to exceed 365 days and a fine not to exceed $4,000. Do you understand that range of punishment? And it appears the plea agreement is that you're going to plead guilty to that offense. In exchange, the state's recommending that your punishment be assessed under 1244A at 90 days in the county jail with credit for 9 days, a $500 fine, $180 restitution, that you are going to serve out the remaining amount of time beginning today. Is that your understanding of the plea agreement?
Yes, sir.
And yours as well, Mr. White?
That's right.
Mr. Mackey, how do you plead to that state jail felony offense? And Mr. Mackey, are you pleading guilty because in fact you are guilty?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this offense?
Yes, sir.
Court will accept Mr. Mackey's plea of guilt. Any objection to States 1, Mr. White?
Okay.
States 1 is admitted into evidence and the court takes judicial notice of Mr. Mackey's judicial confession. Is there anything further from the state? Anything further from the defense? Was there a lab report returned in this case? I have the offense report. No lab report. Mr. Mackey has seen the lab report in this case? Okay, that's fine. All right, based on the evidence before the court's going to find that there is sufficient evidence to convict Mr. Mackey. Court's going to follow the plea agreement. Court convicts him under section 1244A of the state jail felony offense of possession of controlled substance, penalty group 1, less than 1 gram. Assesses his punishment at 90 days confinement in the county jail, issues credit for 9 days credit served, assesses a $500 fine, $180 restitution. Court also assesses a $290 court cost and a $35 reimbursement fee. Mr. Mackey, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. In just a moment, I'm going to have you step up to be fingerprinted and taken into custody, okay? Whenever you are released from custody at the Van Zandt County Jail, I'm going to order you to contact Miss Bonnie LaPrade, the court compliance officer, so you can make arrangements to discharge what you owe the county. Understand? All right, Mr. Mackey, step on up here with my bailiff. Okay. Can you give me 2 notice of settings for them and get them filled out for 9/29? All right, court call CR 15-487, Sean Palmer, and CR 15-503, Tanya Red. All right, Mr. Palmer, Ms. Red, Mr. Green has contacted the court today and indicated that he is not feeling well, so the court's going to reset your case for hearing on your motions to adjudicate on September 29th. And we'll set that, let's set those at 11 a.m. Yeah, that'll take a couple off of the 9 o'clock I'll put on you. Yes, we are. I'm sorry. I should have said that. I've got Miss Taberham doing it. What's your recollection on Mr. McCray? What did he plead to? He pled to the 20. I'm trying to figure out Mr. Knoll's billing. your probation fees and your analysis fees have been waived by the department. Why are we seeking to extend your probation?
They're saying, I don't know money yet, and, I don't mind, because I was having some financial problems with those things, and now I'm working. And they, I have to see my probation officer for, and I asked for the extension, I understand.
Okay. Okay.
And that's 12 months.
Okay, so you're requesting to have it extended so you can comply completely, pay off.
Everything paid up, and my time paid up to that too.
All right. And has anyone threatened you, forced you, or pressured you, telling you that you have to extend your probation?
No, I'm the one that wants to do it.
All right. All right, then the court's going to approve the amendment to your conditions of community supervision and orders that your period be extended for a period of 1 year, ending on September 17th, 2021. And the court orders your probation fees and your analysis fees waived. All right, you come back here and see Ms. Burns and you'll be free to go. Can I sign these when I get back if you need them right now? All right. You may, Aaron, did somebody take your prisoner?
Yes, sir.
Okay, good. We got some nice size we got to do. Jill. Oh, thank you for doing that, Hillary. Perfect. All right. Here's that warrant. These two. This is my plea for this afternoon. That one. Let's try to get, if we can, let's try to get Mr. Hyde's guy. Adam Sides.
Pretty early on.
Yeah, if we can get him number one, we'll get that plea and get that done. All right.
Just a second, Judge.
No,
Okay.
I didn't know.
He's not?
Sides number one. Handwritten note,
Well,
just as good.
how
And I
did,
took off.
how did he get on it?
Abram Rice. I guess he just requested it.
Hey, Danny, did anybody call over to tell us that we were doing size today? Heath just came up and kind of stuck it in my face and said, hey, we're doing this. It's a waiver of indictment.
Yeah. He was set. I think he was set, no?
Let's look. CR 2235.
Another was just retained Friday.
This admin need to prepare, an ISI for Mr. Flores, which is set for Raymond.
Yes, Perez, and then, yeah, that's the only one. Powers is a motion or a vote. Yeah, double check that that one's active, but no response.
No response to audio.
All right, the court having called CR 2189, State versus Martin Perez, who was not present in the courtroom. His name has been called loudly distinctly 3 times in the courthouse with no response. Court issues a judgment nisi and alias capias. Will set new bail in the amount of $100,000. Cause number CR 17165. Courtney Lynn Powers. Courtney's Powers' name was called in the courtroom with no response. Her name has been called loudly, distinctly 3 times in the courthouse with no response. Court will issue any judgment nisi and alias capias in that case and set new bail at $150,000. All right, 1:30. Hey, we did a bunch of pleas this morning. Stephanie was busy.
So he has a 4-year MTR, and then his MTR was based on the new offense in Dallas. So his attorney and I agreed to agree